All right, I will call this second meeting of the Senate Judiciary Committee to order. Okay. Will the Secretary please call the roll?
Senator Flores.
Present.
Senator Orenshaw.
Here.
Senator Lang. Here. Senator Wynn.
Here.
Senator Hansen.
Here.
Senator Krasner. Here. Senator Ellison. Chair Scheibel.
Here. Thank you so much. So welcome back to Senate Judiciary. Today we have two presentations on our calendar, and I want to welcome you all back here. We also have a couple of introductions that I want to make. I was remiss yesterday in letting you all know that Shauna McManus will also be helping us as our another research policy analyst because we have so many bills here. It takes a lot of people to make this thing work. So she'll be joining us. I also wanted to give my colleague, Senator Orenshaw, a moment to introduce himself. He has been a member of this committee for a few years now. He's an excellent resource for all of us. We're very lucky to have him, and just wanted to let you tell everybody a little bit about your service.
Thank you very much, Chair. James Orenshaw, I represent State Senate District 21 down in Southern Nevada. I practice law as a deputy public defender in juvenile court at the Clark County Public Defender's Office, where I represent children. And I've been very lucky to get to work there and to try to fight for my clients and try to help get the best outcomes I can for them. I've been very lucky to serve on this committee with Chair Scheibel and your excellent leadership, and look forward to working with you this session, Chair. And thank you.
Thank you. All right, I think with that we are ready to go into our two presentations for today. Our first presentation is from the courts, and in case it's not clear, the purpose of having presentations at the beginning of the legislative session is as a refresher, an introduction for members who are new and returning to the committee, because our court system is complex in Nevada, and so this is going to give us kind of an overview of the pieces and the parts, so that when we talk about them later on in session, we are all coming from the same point of reference. So I understand that we have the Chief Justice of the Supreme Court, Justice Herndon, in Las Vegas today. It looks like he's coming up to the table. I believe we have Catherine Stocks here at the table in Carson City, along with John McCormick. I am going to turn it over to the three of you to present a little bit about the courts to us. It looks like you also have a PowerPoint, and then at the end, I'll take some questions from the committee. Please go ahead.
Thank you very much, Chair. Douglas Herndon, for the record, it's D-O-U-G-L-A-S, last name H-E-R-N-D-O-N. First off, it's very nice to see all of you again. And Chair, thank you again for introducing me the other day to the Senate for the swearing-in ceremony. I appreciate it very much. I know all of you have been involved with the legislative committees, including Judiciary, some of you, for quite some time, and you're very familiar with the court system. Nonetheless, I do appreciate the opportunity, along with our court administrators, to present a brief overview to you. And I'm going to speak for just a moment, then I'll turn it over to Ms. Stocks and Mr. McCormick. And I apologize in advance. If anything that we're presenting to you sounds at all remedial, I agree with the chair that I think it's just kind of good to give you a very broad overview of the court system so that you all have a kind of an understanding of where we are now. As you know, Nevada has 17 counties. Those counties are divided up into 11 judicial districts. And at its core, it's kind of a population thing. So there are certain areas, certain judicial districts that are comprised of multiple counties because of the smaller populations within those areas. Areas like Clark County, for instance, are its own judicial district, as is Washoe County, Elko County, and so forth. Within those 11 judicial districts, we have essentially 4 different court systems in the state, combining 5 levels of courts. So we have the municipal court system, we have the justice court system, we have the district court system, and then we have the appellate court system. The appellate court system is both the Court of Appeals as well as the Nevada Supreme Court. Under our model, in the municipal courts, for instance, those courts are in the municipalities and cities around the state, but not everywhere. And again, it's generated a lot by population. So there are actually only 17 municipal court systems throughout our state, and there are 30 municipal court judges, I believe, sitting in those areas. the justice court system, which kind of has overlapping jurisdiction with the municipal courts on many things, primarily misdemeanor criminal offenses, low dollar level civil traffic matters, and so forth. The justice courts pretty much in every county, but it's not necessarily a county justice court. So for instance, Clark County has a Las Vegas Justice Court, a Henderson Justice Court, North Las Vegas, Mesquite, Laughlin, Moapa Valley, Good Springs, Boulder City. The justice courts are in all those areas within the county. Total around the state, we have 40 justice court systems, and there are 67 justices of the peace serving in those systems. The district court system is the state's trial court system, and those are state judges with all the other staff members and physical space provided through the counties. We currently have 90 district court judges serving around the state. When we go back to that idea of multiple counties in one judicial district, you can appreciate that the district court judges in those districts have to travel quite frequently to be able to hear cases in multiple areas. So a district court judge in the 7th Judicial District, for instance, will be hearing cases in Eureka County, they'll hear cases in White Pine County, they'll hear cases in Lincoln County. That will tie in later to some of our requests under AB 66 to assist those rural districts in getting extra judges, particularly the 1st, 6th, 10th, and 11th. But we'll leave that for another time. And with that, the last thing I'll say is, I'm sure you're aware, we have a non-unified court system in Nevada. So that simply means that there's no one system of organization where all the courts are kind of in the same game, so to speak. The various court systems around our state in a non-unified system, they retain a large measure of discretion as to their administration and the rules they promulgate for themselves. With the appellate court system, I should have mentioned that, I'm sorry. We have the Court of Appeals, which is comprised of 3 judges, and then we have the Nevada Supreme Court comprised of 7 justices, including Justice Stiglitz, who's present with me today, and myself, and then Justices Paragary, Pickering, Kadish, Bell, and Lee. All of the appellate cases in Nevada, based on the way our system is structured currently, come to the Nevada Supreme Court, and then we push certain matters down to the Court of Appeals to assist us with. Some of those or most all of that is defined by our internal operating procedures in terms of what the Court of Appeals will handle versus what the Nevada Supreme Court will handle. And with that, I'm going to go ahead and turn it over to Ms. Stocks and Mr. McCormick, and I will be happy to answer any questions at the end of our presentation. So thank you again for your time.
Thank you, Chief Justice. Catherine Stocks for the record, KATHERINESTOCKS. Thank you for having us here again. This is my 2nd session in person, 3rd session with Nevada, and it's good to see faces that we worked together closely last session. Today, with the overview, Justice Herndon did such a good job of doing this introduction. It shouldn't take too long for Mr. McCormick and I to go over the slides. We are proud to say that we released our annual report, and there are copies available for members if you're interested. I don't know, were those handed out? Okay. So this gets into the specifics. We're required by statute to produce this, but it talks about the judiciary as a whole. It has case statistics in the back half, divided by district. We have extra tables online that go much more in depth into the case processes at the court level. We have aggregate statistics from our position in the AOC. We are happy throughout session to meet with any of you that are interested that might have questions about the annual report or more specifics about the operation of the judiciary. And Chief Justice Herndon already covered this slide. Mr. McCormick, was there anything we left out?
No, John McCormick for the record, first name J-O-H-N, last name McCormick, M-C-C-O-R-M-I-C-K, Assistant Court Administrator. Here, this slide you'll see is just sort of a visual representation of the Nevada Judiciary and lines of appeal on here, and we'll cover the specifics on this in just a little bit. As Justice Herndon indicated, we are Nevada's judicial system, the judicial branch, being separate and co-equal branch along with the executive and legislative branches as provided in Article 3, Section 1 of the Nevada Constitution. And the reason the judiciary exists, we think, is it is our responsibility to resolve legal disputes in a fair, timely, and impartial manner. And many of our initiatives are obviously pushing in that direction. And Justice Herndon kind of covered the levels of court, but again, we have the appellate courts being Supreme and the Court of Appeals District, and then Justice and Municipal Courts as well. And as Justice Herndon mentioned, we are a non-unified judiciary here. The Supreme Court is Nevada's state ultimate judicial authority. The court's decisions become case law precedent here in Nevada. It is our final appellate court, and as Justice Herndon indicated, it receives all appeals from district court and has discretionary review of appeals from the Court of Appeals. The Supreme Court has a couple functions. It serves as an error correction court, so if there was an error made at the district court level, that's one function of the Supreme Court, is to correct those errors, and also the court of last resort, meaning it is the final authority on questions of Nevada law. The only thing that can go sort of up to the United States Supreme Court from the Nevada Supreme Court are issues dealing with constitutional rights, etc. And one difference here, I did mention that the Supreme Court takes all appeals constitutionally. It's obligated to do as such. And then they screen cases, and some going down to the Court of Appeals. That's, I think it's Nevada Rule of Appellate Procedure 17 is the rule where that's found. If anybody's really excited to read Rules of Appellate Procedure. But again, we have 7 justices, and another function of the Supreme Court, particularly found in Article 6, Section 19 of the Nevada Constitution, is the Chief Justice is the administrative head of the judicial branch. And we'll talk a little bit about how that plays out and what that means in a moment.
Catherine Stocks for the record. This next slide is about the Court of Appeals, and as Chief Justice Herndon mentioned, Nevada has a push-down model. So the Supreme Court, through their internal operating procedures, determine what cases the Court of Appeals will cover. And with that, if there are any questions about the internal operating procedures, we can have those conversations throughout session. There's a public document related to it, but they can be pretty specific about how those decisions are made. And there are 3 members of the Court of Appeals, and I think that covers it. So next we come to the district courts, and you're probably most familiar with district courts, looking in the room here, especially with those that are practicing. And these are courts of general jurisdiction, which means that they are courts of record. They handle more complex cases, and it's a variety. A district court judge could be specialized depending on the size of the court. In our smaller districts, those general jurisdiction judges are covering every type of case. So from a probate to complex civil litigation, water rights, even all the levels of felony criminal cases. So we also, though, in the 2nd and the 8th, which is Washoe County and Clark County, those district judges might have the ability to be specialized, where by statute we have family court seats. So that is a district judge. However, they are not general jurisdiction. They are dealing with family court matters. There are, and as the Chief Justice mentioned, there's 11 judicial districts in our 17 counties and 90 district court judges.
John McCormick for the record. So I turn on the mic. John McCormick for the record. Sorry about that. I'm used to the bigger buttons that, Anyway, justice courts are limited jurisdiction courts, meaning their jurisdiction is set by statute. It's NRS 4.03370, I think. Sorry about that. But again, so they have limited jurisdiction, meaning that their civil threshold is up to $15,000, and then district court takes over once a general civil matter surpasses that monetary threshold. They also have small claims jurisdiction up to $10,000, and small claims is a more simplified sort of court process with less formal rules of evidence, etc. The idea is that it's a way for citizens to resolve those small dollar disputes in a more sort of efficient or user-friendly manner. Justice courts also handle landlord-tenant, so eviction matters. That's where that's primarily heard. They do protection orders. Our protection order jurisdiction in Nevada is a little bit different. We have several types of protection orders here. Protection, domestic violence, stalking, harassment, protection of minors, high-risk protection orders, those being the red flag orders, and protection orders against sexual assault. In 15 of our counties, justice courts do all those protection orders. In the urban jurisdiction, so again, the 2nd and the 8th, as Catherine indicated, domestic violence and high-risk protection orders are handled by the family bench, so there's a little variation in that jurisdiction. And also justice courts have traffic jurisdiction, so they handle both misdemeanor traffic and civil traffic infractions as well. As Justice Herndon indicated, 40 justice courts, 67 justices of the peace, and those are in Fort Township. And district court, I think, as we indicated, and on that earlier slide, has appellate jurisdiction over the justice courts. Municipal courts are our other type of limited jurisdiction court in Nevada, and municipal courts are exclusive to incorporated cities in the state. 17 municipal courts, 30 municipal judges, and 8 of those judges do double duty as the justice of the peace and the municipal court judge. For example, in Elko County, in Wells, Carlin, and Elko, those justices of the peace are also the municipal court judges for those communities. Again, Judge Toon in Mesquite does double duty, and recently Judge Miller in Boulder City was one of our double duty judges, but he actually retired from being a JP and is now just a municipal court judge, which is why, if anybody's paying attention, the number of dual judges went down by 1 since last session. And again, municipal court, all municipal court appeals are heard by district court. The big difference between justice and municipal court, aside from that geographic jurisdiction that municipal courts are in and for the incorporated city, is they have significantly less civil jurisdiction than a justice court does. Municipal courts don't hear those general civil cases up to 15,000 or small claims up to 10,000. They do have civil traffic jurisdiction, and then they also have some limited civil jurisdiction, generally dealing if there's a municipal utility, collections on that, sometimes barking dog, neighbor disputes, and administrative review of city decisions and those type of things. So that's the bigger difference there, is there's the limited civil jurisdiction at the municipal level.
Catherine Stocks for the record. This is a slide that talks about what we do. So when people ask, well, what is the AOC? What are you administering? We're actually not just supporting the central services of the appellate courts, which is a critical function of what we do. There's also statutory requirements on the state court administrator. Part of that is related to data and providing information, collecting data, and making recommendations for the improvements of the court system as a whole. This is a long list of the different things we do. The annual report highlights them as well. What is the most fun part about this is we get to effectuate the court's strategic plan. We get to work on issues that deal with individuals on a daily basis at the trial court level and at the appellate court level. The entire Nevada Judiciary has major objectives to effectuate their core constitutional duties. And we get to do that with littler projects, and then the bigger projects that the legislature has supported, such as rolling out statewide e-filing, a new cloud-based case management system to improve the way our trial courts process cases every day. We're rolling out an updated appellate court C-track system that is part of the access to justice piece, because we are able now to have self-represented litigants e-filing into the appellate courts. The Supreme Court has effectuated new rules, updated the rules to modernize the way that courts operate. And that's the really fun stuff that we get to do at the AOC. And again, there's the offer. If you have questions about any specific programs we support, we are available to meet with you about those, or answer briefly during this one if there's a burning question.
And John McCormick for the record. On this slide, I'd also just like to point out that we do have our guardianship compliance office. We'll be hopefully talking with you folks a little bit more about some of those issues later this session in a piece of legislation that we've proposed on that. But that is the office that assists district courts in their oversight of guardianship, providing forensic accounting, various investigatory services. So just wanted to mention that. And then one of the things we do at AOC is support specialty courts, and we're very grateful for the support that this body over the years has provided for specialty courts, and it really enables us to grant that money out to local trial court programs. You know, and a specialty court, what is it? Fundamentally, it's a therapeutic court that uses evidence-based practices, treatment, and case management to address underlying factors that contribute to criminal behavior, substance abuse, mental health, etc. The Specialty Court Funding and Policy Committee, which Justice Stiglitz, who's down in Las Vegas with Justice Herndon, is one of our co-chairs, along with Justice Linda Bell. But that Funding and Policy Committee sets priorities, distributes funding, makes policy decisions regarding the operation of specialty court. And we're currently funding 64 trial court specialty court programs to the tune of about $8.49 million. A couple stats I just wanted to share. In 2021, which is the most recent year, we have data available because of the 3-year period that we use as a measure of recidivism. 77% of specialty court graduates did not recidivate. So almost 80% of people who graduated, successfully completed a specialty court program, have not recidivated. And also, kind of another interesting statistic, in the same year in 2021, if a participant was dismissed from a specialty court program for whatever reason, failing to comply, all that stuff, those folks recidivate at a 45% rate, which is a lower rate of recidivism than people who've not gone through a therapeutic court program. So even when folks are not successfully completing the full scope of the specialty court program, we are seeing a reduction in recidivism through receiving some of that treatment. And then again, in fiscal year 24, in the annual report that you have, we had 1,320 people graduate from specialty court programs in Nevada, and among those graduates, we had 36 babies born without substance exposure due to the program. So just wanted to highlight that on specialty court, and that's sort of the end of our overview, trying to be respect your time on that, and we're happy to stand for questions. Thank you.
Thank you all so much, and welcome to Justice Stiglitz as well. Thank you for joining us, and I will go ahead and take questions from the committee. I also want to commend our presenters on giving us their names and their spellings before they began speaking. I was supposed to remind/tell all of you to do that, so just be like these presenters and give your name and the spelling when you start. And just remember that all of this is being recorded and being transcribed into minutes, and so even though for us we might be able to tell who's talking, when we go back to review the record later, it makes it much easier when people put their name on the record every time they speak. And so with all of that being said, I think that Senator Wynn had a question, or maybe a few questions. Please go ahead, Senator.
Thank you, Chair. I have a question regarding, you had mentioned, I think it was Justice that had mentioned this, that we don't have a unified court system. And so each of these courts have potentially different systems. So even within a city jurisdiction or a county, you could have conceivably 3, 4, 5, 6, 7, 8 different types of court systems. Have there ever been any pushes internally or under the leadership of the AOC to encourage people to utilize the same system?
John McCormick for the record. Thank you, Senator. So in terms of using the same case management system, we have, we being the AOC, provides a case management system statewide. It allows courts to access a high-tech case management system at significantly lower cost. I think we have currently 34 courts on that, and we're currently engaged in the process of upgrading that to the new version, cloud-based, for wider dispersal. So we do offer that. Again, we've taken a more active role in creating sort of rules for everybody, like our electronic filing rules that go along with the e-filing system that we're rolling out and is available to all the courts in the state. So we are making those efforts to bring some more uniformity and bring some tools to the various trial courts.
And Chair, may I follow up? When you said there are 34 jurisdictions that utilize this common, like, I guess, case management system, how many different jurisdictions are there, though?
Currently, well, there's the 11 judicial districts, and then the 40 justice courts, and the 17 municipal courts, I think. I'm not looking at the crib sheet. So of those, most of the ones that are utilizing our case management system, and we can get the specifics on this, but are limited jurisdiction courts. And one of the big things that we're excited about with our new, sorry, John McCormick for the record, I didn't say that. One of the things we are excited about with our upgrade is getting more district courts on board. And then we do have some uniformity in vendors across the state. For example, some courts in Washoe County and in Clark County use the same case management system. But again, that's one direction we're pushing, and we're trying to provide the resources to get there rather than saying you shall.
When people utilize those unified, like, court filing systems, I mean, I've heard from judges, I've heard from prosecutors that they routinely have an issue, like someone could commit a crime in Henderson and be under the jurisdiction of a Henderson court, and then they could go over to Laughlin or Las Vegas or both of those places and commit another crime, and there would be no communication between all of those courts. Would being under a unified court system allow for easier access to things that are happening in other jurisdictions?
Catherine Stocks for the record. Part of me, not having the Chief Justice sitting next to me to know who's going to take it is hard. So in this, are you ready to go, Chief Justice?
Sure. I had hit the button. This is Douglas Herndon on behalf of the Supreme Court. I think that the best answer to that, Senator Wynn, is I'm unsure, to be honest. I don't think that a unified court system would necessarily solve the problem of lack of communication between law enforcement agencies. This was something that we dealt with somewhat when we were doing the pretrial risk assessment committee and trying to put together the tools to allow judges to make better bail decisions, i.e. that there wasn't a lot of communication between the law enforcement agencies with a similar type of system so that we as judges could access information from around the state to have an accurate picture of somebody's criminal history. That was one of the things we were trying to work on as far back as 10 years and we're going to, I'll just add as an aside, I'm reconstituting that committee beginning in February or March to revalidate that tool and see what advancements have been made that might help us gather information better. But I don't know that necessarily a unified court system would be communicating any better on that. It might, to be honest, it might, but I think that remains to be seen. That being said, I think we do try when we know there are issues that are affecting everybody around the state and can bleed into the various districts to try and encourage the courts to be more quote unquote unified. I mentioned when we were with you all for our pre-session budget hearing, the idea of our water courts. We recognize that water issues arise in all of our judicial districts around the state, so we created the water court program to try and train district court judges in each district so that they would be handling matters in a very similar fashion to give predictability to attorneys and litigants as to how those matters would be handled. The same thing when we created our virtual advocacy commission. The core function of that was access to justice. Let's create ways to encourage courts around the state to deal with remote hearings in a similar fashion so we can ensure that more attorneys will be available to go to rural areas to hear cases, knowing that they don't necessarily need to drive every time from Las Vegas or Reno to Elko or Ely or Eureka to handle a case on somebody's behalf if they can appear remotely. So we encourage the judges to do all that in a very consistent fashion through the use of those things. So even though we're not unified, we do try where we can, respecting each jurisdiction's independence, to encourage them to be quote unquote unified.
Thank you for that answer. I have a question you had mentioned something about the water courts, so this kind of has to do this. I know the courts have created like their own judicial training system kind of outside of that statutorily required National Judicial College. And so I know I've heard from other lawyers and I've heard from people that don't practice law that sometimes cases that are extremely complex, especially in the area of water or even in our business, like with our business community, they want that consistency of having people that are trained. Do you anticipate that you will use programs like your water court program or this additional training program to, I guess, give some more resources to judges that have general jurisdiction but sometimes get very complex cases that need more specialized knowledge and training in an area?
Thank you, John McCormick, for the record. Currently, in addition to the statutorily mandated attendance at the National Judicial College or the National College of Juvenile and Family Court Judges, we do have a judicial education program. We offer one district judge and seminar per year with extra family there, and then 2 limited jurisdiction conferences a year. We have a specialty court conference every other year. We're obviously working on the water law, water judge, whatever you want to say, program, and we've had that training. In the past, we had training for district court judges specific on med-mal and that medical malpractice in that area. Another thing that we do offer, we have a set aside of funds for elective education where judges send a request to us and we can approve it to send them to those specialized classes. So they have that opportunity for that. We regularly engage with the education committees of our Judges Association to make sure the topics that we're presenting at those conferences are what they need, what they want to be hearing, with the information they want to get. So we do try to do that. And one of the issues, I think, is the economies of scale. Like with the business court judges in Clark County, for example, that's maybe not going to be the same training need that we're having in the sort of jack-of-all-trade judges in say, Elko. And so we try to fund them to go to those specialized or more specific classes.
Catherine Stocks, for the record. We actually have a subgroup of the Judicial Council that is working on family court issues right at this moment. And that work group, I don't know who all is familiar, but recently there were short trial rules essentially modeling what has been successful in civil into family. And this group is doing what I think you're getting to, Senator, is they are also focused on the complex divorce. This is more prominent in Nevada than in the past as the state continues to grow. And estates are now, there's always some people with complicated estates, but our judges have noticed the need for specialized training related to asset allocation in divorces. And that's another project that we're working on. That should be coming out within, it is something that started in 2024, and we will then seek, if possible, grant funds to bring in specialized training expertise for our judges to support those complex divorces that wasn't on the radar 5-6 years ago.
All right, thank you. I think Senator Allison, did you have a question? Please go ahead.
Thank you, and thank you for being here. I've been involved with around the court system a lot through the years, through city council and county commissioner and then legislature. My deceased wife worked for Elko Justice Court for 33 years. So we got involved, and her sister was a judge in Weld. I really enjoy the way the justice court systems work and travel. And if they need visiting judges and whatever, they all jump in there and help. I thought that was amazing, because to me, the justice court is the court of the people. And I think that is where some of that stuff gets lost. I mean, we're lucky. I mean, we've got some of the best district judges and JP judges anywhere. I can't say enough good about them. But one of the things that really comes to the table is you can help is the video conferencing is probably one of the most important things we can do. We're saving money to the state, we're saving money to the attorneys in travel, we're saving money to the individuals that have to appear. I think that's one of the greatest things we can do. And a while back, they had a traveling judge that was doing 2 counties at once, and that created a problem. Couldn't that have been handled better by going video conferencing? Maybe you can answer that. But I'm pretty proud with the system that Nevada does have. And I did sit on a short committee in Washington, D.C. on courts. So it was quite interesting.
Douglas Herndon, for the record, on behalf of the Supreme Court. Senator Ellison, I agree wholeheartedly with you. One of the things I can tell you, and because they practice in Clark County, I'm sure Chair Scheibel, Senator Wynn, Senator Orenshaw realize this as well. One of the things that came out of the COVID pandemic was a realization that I had far more out-of-custody criminal defendants appearing for their cases when they were able to appear remotely and not have to miss their job or struggle to find transportation, any number of things, than used to appear before COVID, when everybody had to be there in person. We issued far more bench warrants for people during that time than we did once the embracing of the need for video appearances became available. And every case in which I knew that there was a question about somebody maybe having to go into custody, even though they were out of custody, when I would continue that hearing over, they showed up for court, even though they knew they may be going to prison on that day. So not only did it have a place, it had a better place than some of the systems we had previously. And so we are very cognizant of the place of remote technology and video appearances around the state, primarily because of what you mentioned and what I said earlier about access to justice. It gives us an ability to ensure people get representation when they may otherwise not have representation. I ran the senior judge program with the Supreme Court up until about 6 or 7 months ago when Justice Stiglitz took that over. The judges was a component of that. We tried wherever possible to arrange for video appearances by the senior judges when they needed to appear in a district court around the state, so that they didn't have to travel and we didn't have to expend public monies on that. Sometimes we were successful. Sometimes the judges that were not going to be there preferred to have somebody in person. So we try and be respectful of that as well, while encouraging them to allow the judges, not just the litigants and attorneys, but the senior judges to appear remotely as well. As much as we can encourage that, we do.
And thank you. I totally agree with you. And I think anything we could do at the legislative level to help expand that, that'd be wonderful if we could. I think that is so important, and not only that, but safety. You know, Senator Goguchi and I were involved with expanding the jail and justice court in Ely, and that was one of the most dangerous courts I ever saw in my life. And it turned out great because everybody come together and built that new facility. So I can't thank you enough, and I just want to say thank you for what you do. Thank you.
All right, thank you. I think Vice Chair Flores, you're next.
Thank you, Madam Chair, for the indulgence, and thank you all for that wonderful presentation. I was looking at the annual report, and I know we've mentioned access to justice now multiple times. I know on page 16 there is a reference there to the legal kiosks. I think there's 25. I was just curious to learn more about them. I was interested particularly in the mention of legal aid. Is this family law? civil, criminal? Are you getting extracting information like that? Do they have it in other languages? And then I'm also just curious to know, is the kiosk providing information that wouldn't generally be found, say, if you just visited the court's website? I was just interested in knowing a little bit more about that, please.
Catherine Stocks for the record. Thank you for that. That was like a way to tee up us talking about the good things that we're doing with the self-help portal. So the initial legal kiosks came through the Access to Justice Commission, and they received a grant to deploy those. Those were initially primarily focused on elder law. That was the scope of the grant. What we now are doing with the AOC is we are expanding what the kiosks will be. I believe the first one with integrated e-filing into it, which means the e-filing is in the kiosk, not integrated into the case management systems yet. I believe that is either already deployed or being deployed in Lyon County. I'm trying to answer in order of, I think, how you asked these. The chatbot that we have for our civil legal help self-help center, which was put together in conjunction with Legal Aid Center of Southern Nevada, and the chat has 50 different languages available. And we did an open house a few months ago and invited people to come in and play around with the chatbot and try to break it, right? We wanted to really test it before it went live. Our metrics now on the help that we're providing, we've already done over 400 petitions for divorce through the portal. And what it is they're the guided interviews. So they're like a TurboTax for law that then create a legally sufficient pleading after the individual answers the questions. Now that is not yet in 50 languages. The chatbot is, but that's part of our progression. So we're making positive steps toward this. And if you're interested, I'm happy to send you our most recent report. We just have our January numbers of who we've served, where they're coming from, and the types of case information that people are requesting.
Thank you for that. I would love that information. Madam Chair, if I could be indulged with one additional question. I know every single committee is talking about artificial intelligence. This is no different. I'm curious to know, is there a process in place now, say Court A versus Court B want to implement the use of artificial intelligence? Is there a transparency mechanism where we know that that's being implemented, what it's being used for, how it's being utilized, where it's happening in Court A but not happening in Court B? Or is there a generic metric or rule better said we're implementing it all across the board? I'm just curious to know how artificial intelligence is now playing a role.
Senator Flores, this is Doug Herndon on behalf of the Supreme Court. I can tell you that within the Supreme Court, we do not allow our chambers to utilize AI in producing any of our bench memos, orders, opinions in the cases. We're still relying on human labor for that. We've worked with LexisNexis and Thomson Reuters, I believe, to allow a couple of chambers, one of which was mine, to be guinea pigs for utilizing, kind of just playing around with AI. We don't utilize it in the cases, but we allow our law clerks to kind of explore it, see how it would affect things. It's a closed system so that nothing that they do goes outside of that system and it gets deleted at the end of the session. But so they'll kind of say, hey, write me a letter about this legal issue and just kind of see how that works. Catherine, I was also going to ask if you would comment for Senator Flores about and I may get the terminology wrong, but the response augmented generative tool that's part of our self-help website now, that I think is the first in the nation to use something like that I also think may be germane to the question that Senator Flores was asking. But within the trial court, Senator Flores, I think because they are all independently elected judges, they're probably making certain determinations within their own chambers as to what they're going to utilize or allow to utilize within the parameters of AI assistance.
Thank you, Chief Justice. Catherine Stocks for the record. Yes, so the chatbot that I mentioned, it's called a RAG chatbot. That's the acronym, Retrieval Augmented Generation. And It is not an open AI where the floodgates, just anything and everything can happen, but it significantly increased our ability to anticipate questions with the chatbot. There is a human component monitoring the questions and responses that come through, but that's also why it's now in 50 languages. We could not have done that without the AI, because the cost for us to pay for the translation of standard chatbot responses and the time it would take for that, it would be expensive and we would be asking you for funds. But that's where the RAG chatbot has really helped us be able to improve access to justice that way. So that particular element is AI.
Thank you for that. Thank you, Madam Chair.
John McCormick for the record, and just one quick follow-up on the AI piece. That has obviously been a big topic of discussion amongst our judges, and so we've really begun to have more educational sessions about that, talking about the pros, cons, plus, and all that stuff. So it's something that's being discussed within the branch, and we are providing education on it as well.
Thank you. I think Senator Orenshaw also had a question. Please go ahead.
Thank you very much, Chair. And Chief Justice Herndon, Mr. McCormick, Ms. Stocks, thanks for the presentation. My question has to do with page 19 of the annual report on specialty courts. Practicing in juvenile court, firsthand I've seen, children participate in the Detention Alternatives for Autistic Youth program, and a lot of kids on the autism spectrum who never got a diagnosis, never got any treatment, getting diverted into therapy, into therapeutic programs. I've seen that be helpful to those children, and I see some of the other programs here that you list, and I laud that. I appreciate everything that the courts are doing with these therapeutic courts. I just wondered, do you see any plans to try to expand those therapeutic courts in other areas, other districts? I just wondered if you know of any plans, or if you think that we're going to see an expansion on therapeutic courts, whether it's for addiction or anything else.
Thank you, John McCormick for the record. That's one of the things we're always looking at, is expanding specialty courts. What sort of gaps can we fill? What's the new research telling us about models to use and implement? As I indicated, we have 64 programs across the state that we're currently funding. So some of it becomes a matter of having the money to fund the additional programs, because we don't want to take money away from our existing programs that are doing a good job. Not specifically, but in broad terms, yeah, we're always looking to expand the reach of our specialty court programs and provide, more access to them. But specifically A, B to C, I don't know that we have that plan.
Okay. All right, thank you, Mr. McCormick. Thank you, Chair.
Senator Orenshaw, this is Doug Herndon on behalf of the Supreme Court. I think that is something that is always open, and it's an evolution, and you have to remain vigilant of identifying those things. You and I have been around, remembering back when it was just drug court, for instance, down in the 8th Judicial District. And then the success of that spawned, hey, maybe we need a DUI court for alcohol offenders. Maybe we need a mental health court. Maybe we need a veterans court. Maybe we need a gambling court. We both know that oftentimes when you're evaluating defendants who have committed crimes, they have a drug problem or an alcohol problem or a mental health problem, or sadly, quite often, all three of the above, in addition to their issues arising in different ways. Veterans with PTSD develop drug and alcohol problems different than other people do. So we've tried to always be cognizant of increasing the types of programs that are available to specialize in for people. But as you can imagine, it's kind of resource driven. So we are always very thankful for what the legislature gives us in funding those specialty courts, and always vigilant about expanding them wherever we can.
Well, thank you very much, Chief Justice Herndon, and I do appreciate everything that the courts have been doing in terms of trying to work on these therapeutic programs to try to help people.
All right, any other questions from members of the committee? I'm not seeing any. So thank you so much for your time and for all of those explanations. I think we're off to a great start getting, our bearings and understanding how the court systems work. So thank you for your presentation. We're going to call up here next the Department of Indigent Defense Services. The Department of Indigent Defense Services, as you're all about to learn, helps ensure that everybody in Nevada gets legal representation in their criminal cases where they are entitled to said representation. And so I think this will be really helpful for our committee to understand, how we go from simply having the right to have an attorney appointed for you to actually having that attorney appointed. And with that, I will turn it over to Mr. Handy and I think Ms. Roberts here in Carson City. Thank you. Go ahead.
Thank you, and good afternoon, Madam Chair, committee members. My name is Peter Handy. I'm the Executive Director of the Department of Indigent Defense Services. That's Peterhandy. With me today is Brenda Roberts. She's the Deputy Director right now of the department. I've introduced herself briefly for the record.
Thank you. My name is Brenda Roberts. I'm the Deputy Director for the Department of Indigent Defense Services. That's BRENDAROBERTS. Thank you.
And so again, I don't want to make this seem like it's remedial. I know many of you are very aware about what the department does, the kind of interactions we have with different institutions and entities throughout the state. This really is just meant to be a refresher, reminder, kind of 20,000-foot overview of things, and hopefully we get to the end, you'll have some questions for us, and hopefully we can provide you some answers. So essentially we start with who we are. So the department consists of myself, the executive director, 2 deputy directors, and 6 staff members. We're a small agency. We consider ourselves lean, but we are responsible for quite a bit that you'll find out later. Within the department's also the Nevada State Public Defender. Right now that consists of the appointed Nevada State Public Defender and 2 attorneys. They handle trial level cases in White Pine County and appellate cases in several counties that have opted in for receive their services throughout the state. There's also the Board on Indigent Defense Services. It's a 14-member board. It's 13 voting members and 1 non-voting member. And that provides direction to the department, promulgates regulations related to indigent defense services, and helps ensure that we get representation from around the state. Those voting members really come from a variety of places, including from the legislature, the governor's office, the Supreme Court, and the Nevada Association of Counties. So what we do. The chief responsibilities are threefold. Really, it's to ensure that indigent defense persons accused of crimes receive qualified, effective counsel. This really is the core purpose of the agency. We do a lot of other things, oversight, training, those kinds of things. But really our central focus is ensuring that indigent persons accused of crimes in the state of Nevada get the services they're constitutionally entitled to, and that those are effective, appropriately resourced, and continue to do good services to ensure their clients get the best representation that's available. The second is to ensure that those systems that we have throughout the state are sustainable. These systems change over time as the needs of different places change. Sometimes it's based on the number of attorneys available, the number of population in a given county, and we just want to ensure that those are appropriately resourced and are going to be sustainable into the future. And we work closely with a lot of the counties to make sure that when they make changes to their systems, they're doing so in a way that's hopefully sustainable, or that they're aware of reasons why it might not be sustainable in perpetuity, and suggest ideas for them to keep in mind when they continue to have their systems evolve. And third is to ensure that the individual attorneys are appropriately and equitably compensated, trained, and resourced. I'm happy to represent that. I think right now Nevada's appointed hourly rate attorneys practicing indigent defense are the highest paid among the country. I frequently attend national conferences and meet with folks who do this kind of work in Tennessee, Kentucky, Virginia, Florida, and right now we're paying $175 an hour for representational services. Many of them are getting as low as $60 an hour. So I'm happy that Nevada's made a lot of progress in this area, where many other states have not. Here's a brief overview of why we do it. The first 3 are because you tell us to. I'm not going to spend a lot of time citing a lot of the statutes that kind of apply to us. I think you're all very aware, very well informed. Chapter 180 generally kind of gives us the structure and the obligations of the department. It outlines that we oversee the NSPD, where our jurisdiction and authority lay, and where it doesn't. Chapter 7, this is where the board is able to determine the hourly rate. We have a lot of interaction with a couple of other chapters because we sort of end up channeling a lot of the funding that comes from the state for a lot of defense purposes. So a lot of the reimbursements for counties that exceed their maximum contributions amount comes through our office for payment. Sometimes direct payment for attorneys, payment for post-conviction counsel and post-conviction cases, all coming out of funds that the department maintains for payment of the services. Chapter 34 is that account that I was just talking about, which is mentioned next. NAC 180 is where you would find the regulations of the Board of Indigent Defense Services. To my knowledge, they haven't been quite codified yet and put into writing, but they have all been approved by LCB and IFC as applicable, and are currently permanent regulations. There's also the Davis v. State consent judgment, and there's assorted obligations related to the provision of defense services. It particularly applies to 10 counties, but when we're trying to meet those obligations, we expand them to basically set a new bar for minimum standards for defense services throughout the state. And then over here, how we do it. So one of our main functions is to provide oversight of these systems and the attorneys that participate in it. So we have 3 contractual oversight advisors. They travel around the state. They sit in court and watch court appearances. They speak with the attorneys on the ground. They speak with judges, with district attorneys, other persons involved in the criminal justice system to ensure that those obligations are being met. So we have people on the ground who have authority to talk to the interested parties to get an idea of what issues there are. Sometimes they can find an issue and correct the issue the same day so that no other action is needed. They've really been invaluable to understanding what's happening in each of the counties, where improvements might be made, and really ensuring that the mission of the department is being fulfilled. We also have a more passive way of performing that oversight, and that's reviewing complaints from the public, clients from indigent defense attorneys, receiving complaints from other members of the bar and from judges. I tell people when I go out on these meetings to meet with the counties, like, we are the complaint department. You need to let us know if there's an issue with indigent defense representations in your jurisdictions. Certainly we're not the bar. If there's an ethical problem, that should be rooted to them. And of course, my formatting is terrible because I did this in 365 instead of on my desktop. So more about how we do it. So part of what we do is also analyzing workload and attorney effectiveness. And we have a few kind of basic foundational things. The National Center for State Courts conducted a workload study in Nevada, particularly in Nevada's 15 rural counties, and that gave kind of baseline numbers about how heavy a caseload should be, how many hours an attorney should be working in a year to continue to maintain effective representation. We also collect data from these attorneys that are practicing indigent defense through Legal Server. They conduct time reporting. Many of them use it for also note keeping, for data management. It is a robust case management software that many of the attorneys are using to maximum capacity. So a lot of them will keep notes. A lot of them keep their documents and data. A lot of them are using it to communicate with their clients or communicate with other attorneys. The third is reviewing attorney requests for resources and attorney billing. So if an attorney wants to get an expert, an investigator, they'd apply through our office or one of our designees in the counties, and we would review that request and approve or deny as appropriate. And the same thing goes for attorney billing. So attorneys will submit their billing to us. It goes through a review in our department for ensuring that the time is appropriate for the tasks that they're completing, ensuring that the math all adds up in their invoicing. And we also get an idea of how much time they're spending on each of these kinds of cases they're working and how frequently they're doing that. So how long it might take from case opening to case close is being tracked through Legal Server time reporting and through a review of those billings and resources. It also helps us identify when there might be gaps in resources. So as you likely know, there's a shortage of a lot of professionals in Nevada's rural counties, behavioral health providers, healthcare providers, and so we can see where they're coming from and try to better coordinate for indigent defense representatives how they might find those kinds of experts or persons to get their clients in contact with to get best results for them. Another part of what we do is pipeline development. So we work closely with the Boyd School of Law at UNLV to really try and get young, new attorneys into Nevada's rural counties, and hopefully to provide indigent defense services. The primary way we're doing that right now is funding received from DETR, the Department of Employment Training and Rehabilitation. We provide stipends for students to come in the fall, spring, or summer to work as an intern or an extern in a public defender's office. These stipends range from $6,500 to over $15,000, depending on where they are and their educational career. We also provide additional stipend funding for them to prepare for the bar examination should they accept a job offer at one of these offices in a rural county. The department itself, we host several externs or interns each year, and we help familiarize the interns we receive with what the department does, with what a lot of our client agencies do, and we try to get them an idea of what it would be like to work with some of these rural counties and some of these rural places that they might not otherwise familiarize themselves with being in Las Vegas for school. Okay, sure. Another one of our main components is providing training to these attorneys. In addition to the mandatory continuing legal education requirements of the bar, we have regulatory needs. The board has instituted regulatory needs. The criminal defense attorneys obtain 5 additional hours of continuing legal education each year to continue providing indigent defense services, and that be related to actual criminal defense law. To that end, we provide an annual conference once a year. This year it's going to be April 2nd through 5th. If any of you'd like to attend, we'd love to see you. It'll be held in Reno at the Atlantis. It's a no cost to indigent defense attorneys, so we're providing all this training for free. We bring around experts from around the country, in particular legal field each year, to help train our defense attorneys and provide new insights and best practices from around the country. We also provide continuing legal education virtually, so on average about once a month we'll provide an hour to an hour and a half of CLE to our attorney members. That way they continue to have a source of flowing information for new education that's coming into them. And then we also provide kind of ad hoc funding, so they can choose other training they'd like to attend. We just require that it be to a nationally recognized training program. We don't want to send them on vacation, so, but there's some fantastic training programs out there that we've sent attorneys to, including the National Criminal Defense College. There's now a Mountain West Trial Skills Academy that we've been sending people to, death penalty seminars, these sorts of things. So far the responses have been excellent among attendees of these programs. We also provide resources directly to these attorneys. So we provide the legal server case management system. Again, it's a robust case management system. The attorneys are free to use a separate case management system if they'd like, but they do need to keep their time in legal server. That way we have a robust data set that we can work with to ensure that these attorneys are providing robust legal representation. Second, we've been providing the Westlaw Legal Research Platform at no cost to attorneys practicing indigent defense. Normally it's a very expensive cost for small firms to take on their own, and so long as attorneys keep taking indigent defense cases, we'll continue to provide that system to, or that platform to them. Finally, and just recently, we've been able to offer Justice Text, which is an audio-video transcription software. Due to the huge amounts of body-worn camera footage, it's been to put a lot of strain on attorneys and their investigators to have to watch all this body camera footage, sometimes multiple times, annotate it, take notes. And this is a system that allows them to upload that footage into a secure cloud-based storage system, and it will transcribe the footage of the audio or video that's been uploaded. It also provides insights into the system, so it does have some AI functionality where it is identifying certain things that might happen and creating timestamps through the videos that attorneys can quickly access those video points should they need to review it at a later time. The reviews so far have been excellent. Attorneys say they're saving a lot of time and money, depending on the situation, of having to either transcribe it using an outside transcription service, or just the time of having to review the video over and over again when they've been provided with a concise transcript from the system. Finally, reimbursement. NRS 180 creates caps on the amounts that each county must pay for the provision of indigent defense services. It varies by county. Those are all set in statute 180.006. It changes every year by the greater of 5% or the consumer price index for the western states. I think this year the increase was, or last year the increase was just a couple of percent. The year before that it was 5%. I don't know if we have the data yet to see what next year's will be. That should be coming out shortly though. Essentially this is just kind of creating a cap so that the counties can expect what their payouts are going to be over the next year for indigent defense services. And then the state's effectively covering the rest of those costs. So a county might have, let's say, $1 million in expenses for indigent defense services. Their maximum contribution amount might be $500,000. They pay up to that $500,000, and the state would cover the additional $500,000 in expenditures. And that helps ensure, I think, that there's a fair balance between the state's obligation and county's obligation to provide these services without taxing the counties too hard on having to provide these at full rates. So each quarter after review of the reported expenses, we determine whether or not the counties are eligible for reimbursement. Once they are eligible for reimbursement, we start making payments to those counties. A few of our new initiatives. Right now we're creating new uniform systems and forms. We're creating new billing guidelines so we can improve the speed of billing review to ensure attorneys are getting paid in a timely manner. Most of these attorneys are small businesses or one attorney shops. It's imperative they get paid timely and as frequently as they're billing. They really do rely on prompt payment to ensure that their businesses continue and they're able to keep a reasonable salary for themselves. We're also improving consistency through these. So we want the counties to feel secure that when they're making these payments to these attorneys that they know that they're paying for a product that should be paid for. Of course, we all have an independent obligation, right, to ensure that public funding is only going to public purpose expenses, and we want them to feel secure that when we're reviewing the billing that we're utilizing guidelines that are appropriate for that purpose. And again, providing assurances the pay reflects the work being done. New forms are going to be used to improve the speed of review. In the past, we've only had 2 or 3 forms. There are a lot of check boxes to decide what kind of thing you were billing for. It created a lot of confusion and some unnecessary steps. We're trying to make sure we're distilling it down to only receiving information that's important to the department for its review to ensure that first part, that the appropriate things are being paid for, and to ensure that the counties, when they're making those payments, get the appropriate information for their billing systems or vouchering systems to make those payments to the attorneys. And second is social workers for public defenders. There's a significant amount of data that shows a holistic defense assisting the whole person can reduce potential sentences and recidivism rates. Highlights of this are the Bronx Defenders. There are several examples now across the country of this. Part of that is actually specialty courts that you were hearing about earlier that are involved in this kind of a system. But we'd really like social workers to start having more of a presence in public defenders' offices in the space, having them coordinate care, provide transportation, coordinate counseling, help the client get in contact with other services at the county level. They might be helpful in either their case or for their health or to prevent the recidivism. Should help ensure that clients are getting the not only the services that are available to them, but to ensure they're getting the maximum amount of care, that they're getting the best chances they can in their criminal case. And it should help decrease some of the workload the attorneys are already doing to facilitate a lot of these different needs for their clients. And with that, I'm happy to take any questions you might have.
Thank you. Are there questions from members of the committee? Senator Wynn.
You had mentioned the Davis consent order, and I know that there has been obviously some transition. I know we've seen you all in IFC, or I have. I think, yep, I'm the only one. Can you kind of give an update on things that we were able to comply with that order and where we were deficient in that order?
Yes, Peter Handy for the record. Thank you for the question, Senator. So when I came on board now as the executive director for this agency, I kind of did a comprehensive review of things that the department has done in the past 6 years almost to help comply with that decree? And the answer is a lot, right? So from establishing standards to establishing the regulatory scheme we have, obtaining a study from the NCSC, creating some standardized forms, a lot of that has already been completed by the office before I was able to even get into this chair. Really right now what we're looking at are some deficiencies in meeting workload standards. And I've had some conversations with the Office of the Governor. I've seen the GovRec budget. A lot of the things that we've had, I won't say difficulty getting to, but difficulty with appropriately coordinating to get our office to be able to fund has been put in either the GovRec budget. So in the past, we've had to make multiple asks of IFC, as you're aware, to try and get funding to provide resources, to try and provide oversight personnel, providing more funding to reimburse the counties. All of the asks that we've made over the past, I think, fiscal year have been included in that GovRec budget. So we shouldn't have problems going forward, hopefully, in having the amount of funding that's necessary to perform all the functions we need. We've been working with the counties. I've already started contacting the counties that are really facing the biggest workload hurdles. Some of them are already taking action on addressing those. Nye County recently added 3 contractors to their system, so that brings them from 6 to 9. They still have 3 more that they need to get to the workload compliance number. Churchill County just hired another deputy public defender in their public defender's office, so they're at 3 attorneys. I think they have an extern coming on in the summer. But they've also increased their minimum new hire salaries. So I think they said they start new hires at just under $100,000 in their office. And they had an issue where they were only, looked like they were hiring for a mid-level position when they would have taken entry-level applicants. Sorry about that.
Can I follow through with that? You had mentioned that the anticipated cost to be able to, I mean, with all honesty, it seems like the majority of the people where we're deficient are in our rural communities. We're having a hard time getting people to go out there that are qualified, that have training, that can do those types of cases and provide that kind of legal counsel that's required under the Constitution, as well as this, consent order. So you're comfortable with the recommendations in the budget to be able to cover all those, where you won't have to be coming back to IFC over and over and over again?
Peter Handy for the record. Yes, absent something changing in interim. I think there's almost generally in perpetuity going to be an ask at the end of the fiscal year for more funds to reimburse counties, just because costs are continuing going up across the state for a lot of things. But for most of the things the department's doing when it comes to the resource allocation, it comes to oversight, I think those will be well funded in the next biennium in the budget.
Can I ask one more question about the AI transcription program that they indicated they were utilizing, Chair? You had indicated that you were utilizing that. Have you already seen like a reduction in the number of hours that are being submitted by lawyers because of utilization of these transcription programs?
Peter Handy for the record. I haven't pulled the data yet. When the quarter ends at the end of March, we'll pull the full data for the state, and I'll have that looked into.
Thank you. Thank you, Chair.
Thank you. Any other questions from members of the committee? I actually had a question about the transcription service as well, and I'm wondering if any of those transcripts have been accepted into evidence in any of our courts. Also, it seems like we're having some technical issues with our microphone.
Yeah.
Peter Handy for the record. I don't want to just...
Yes.
Off. Yeah.
We'll just take 1 minute recess to address these technical issues. We will be right back.
How are you today?
I think as it thinks, it's actually turning on and off.
Yeah. Yeah. So like, yeah, mine is on. Test, test. Yep, see, it's on again.
Now it's on.
Yep, see, it's on.
Oh, yeah, mine's on.
Did yours come out? Yep.
I'm on again.
Oh, it just came on, you're right.
Oh, no, it's on.
Is your microphone?
It's on.
Mine's going in on and off. Right now it's on.
Great, so you can answer questions in 25-second bursts.
Mine's on.
Now it's on. I mean, I was told once by a court reporter that she could type at 600 words per minute, but she couldn't keep up with me, so I might be able to do it.
Okay.
one piece.
Did he have a control?
He had a screen. Screen where he could control.
Okay, I will call the Senate Committee on Judiciary back into order. It is 2:30 p.m. on Wednesday, February 5th. Unfortunately, we're not able to fix the microphones right now, and I do appreciate everybody's patience. I also know that our tech support team is working really hard on it, and we appreciate you all. And we come back again tomorrow. So you are welcome to join us again, JID's team, if you want, but I think we're also reaching the end of your presentation. I think we were reaching the end of your presentation, so please do not feel obligated to come back.
They're saying that you're working right now, so if you can finish.
And if you are here to give public comment, is there anybody here in Carson City wishing to give public comment? Okay. And I understand there's currently nobody on the phone or in Las Vegas. If anybody does have public comment for today's meeting, I encourage you to submit that online. We will include it with the meeting minutes. And of course, there's always tomorrow. So we will be here again at 1 p.m. tomorrow. Until that time, we are adjourned.